experience in the real estate business, and they should have at least 5 years of experience in real estate education. And when the commission questioned Bobby Wood, who brought your name forward as a nominee for this, he said 5 years is, and what education means are totally different to different people, but he had only high praise for you, and I'd like for him to expand on that and maybe repeat what he told this commission a few months ago. Bobby?
Well, as the story goes out in our area, and we're in Wilson County, and some real estate leaders went to Karen in about June of 1985, if I remember right, or I wasn't there, as I've been told that. That they came to her and said, we'd like to do an association, and so asked Karen to kind of just be the office member, be the secretary, we called them back then, I guess. And so she came and she said, I'm not going to do this real long. She goes, but I'll start it part-time, but, maximum I can do this is maybe a couple years. 33 years later, she retired. And in the meantime of that, she's taken what was just a small group of business people to a very large realtor association. And in part of doing that, and being an association executive like it is, you do a lot of things. I mean, you're responsible for making sure the training gets done and education gets done for all her realtor members in the area. Because of that, a lot of us have referred to her over the years as Mama Karen, because she has this herding kind of metabolism, and I've been the beneficiary of a lot of this over the years. There have been a lot of times when, and I told the commission this when we were talking about it. I mean, I'm the beneficiary in that Karen encouraged me to teach back when I didn't think I could teach, and a lot of her encouragement was not, I want you to teach. It was like, I can remember her going, I signed you up for a class in December, and you need to be there these 2 days, okay? It's already paid for. You just need to show up. And so, which is kind of sometimes how our mama would do things, just do it and push you out. But she was really good about training our agents. The other thing that's true too, because she's kind of been the matriarch of association executives in the Middle Tennessee area, and really probably the state, but she ended up training a lot of the other association executives. Not necessarily formally when she went over there, but she became the one person that everybody had on their speed dial, because when things go wrong, everybody would call Karen. And again, I was the beneficiary of a lot of this. I've been fortunate enough to be president of our association a couple times, and we wanted to do something. We had years ago. We wanted to do a Bass Classic, because a lot of realtor associations will have a golf tournament. And I had a gentleman come to me. He goes, not all of us golf, Bobby. He goes, some of us fish. And so we're like, okay, wouldn't that be a great, crazy idea? And we do this Bass Classic. And so I called Karen. I said, see if anybody else does a Bass Classic. And about 24 hours later, she calls back. She goes, nobody does it. She goes, but everybody thought when I called them that would be a great idea. And so this Bass Classic has been going on for years. I mean, at one point we were doing 2 a year. I mean, and so it's been a great outreach for not only what we've been able to raise money and provide back to the community, but it's just a great realtor outreach in our area. But again, she's been a great help for other associations. She's also been an asset to our state associations. Been chair of the executive boards and executive association executives committees there too, and been an asset to that. And the thing that she does all this stuff without wanting to be out front. And so it's probably killing her right now to know that we're talking about her, because she's not out front. And I was telling Rick just a minute ago about her. I said, this is how she does. I said, well, if you're a president for her, you will love it. I said, because all you got to do is show up, and everything's taken care of. She'll give you the book. She'll say, here's this. And I've been fortunate enough to be the MC of some things that she's done. I mean, and she has the book. She has everything I'm supposed to say laid out, even when she'll may say a little something, tell a story right here, Bobby, or something. But it's all laid out perfectly, and she's been such a great asset to I guess real estate agents throughout our state and through our association. We've been so fortunate to have Karen for all these years, and sure do miss her and miss having her. No, Buzz, we've been fortunate to get Buzz Steele that's come with us now, and he's the new row at our association, and Buzz will do an excellent job, and but there'll always be a void for Miss Karen, and I appreciate everything you've done for us in our our association. And so this is what I'm going to do. Karen, we're going to get some pictures made in here a little bit. And I don't know that I've ever seen us have the state photographer here, but we have a state photographer. So this is one of the few things. And then also, too, Karen, maybe you come up here just a second. Now that you're retired, and let's see if you want to sit right here.
You don't have to, Karen.
Okay. But now that you're retired, well, there's nothing that Real Estate Commission can do to you now. So if there's ever anything you would like to say to the Real Estate Commission, knowing we can't hurt you, now is your time. So I'll just give you that chance.
Well, I think one thing that I've seen that maybe hasn't worked so well, I think we need to still have it a rule to say owner agent. I know it's in our code of ethics, the realtor code of ethics, but not all licensees are realtors. And I think it's only fair to the public to know that if you're a licensee selling a property and it's your property, that that you have it on there.
That's it?
I shouldn't have asked.
Yeah.
I shouldn't have asked.
You want to say anything nice about Bobby? Because
Bobby's been terrific, and so have all of you.
Well, if that's all you have to say, we're going to ask you to come up here. I'm going to ask the commissioners to go around in front, and so all of us will be in a picture with Karen.
And also, our executive director, Caitlin Maxwell, will have something there for you that we're going to get our picture made with you there.
So, Karen, right up here, center, and Mama Buzz, if you don't mind taking a few pictures. Daddy Buzz. Oh, God.
That's what I was thinking. Where are we going? We're going in there. Inside. We're going here.
Let's put Bobby next. Yeah.
I have to count to 3.
Just put it in.
Steve's taking it.
Oh, actually, sorry.
Okay, let's get the group out here.
Get out of the way here. Just give me a square.
Right is flash, colors on the set according to scene.
Just press this button right here. And then take the shot. That's it. Just hold it down.
Okay.
Here, I can take that.
Okay, good.
I wonder why he ended it.
Do they make left-handed cameras?
I don't think so. You have to turn them upside.
Why would I even say Debbie Downer? My job.
Thank you so much for coming. Long time we've known each other.
I know. I'm glad I could keep up with you on Facebook. Getting on there.
That's the only way I can.
I'm sick of saying it.
Here's her. Yeah, that's Lisa.
Well, it's good to meet you, sir.
Yeah, you too, John.
Buzz, always a
Congratulations.
pleasure.
Thank you.
Well deserved.
Good to see you, sir.
I appreciate
I'm
it.
glad you're enjoying retirement.
I am.
Good to see you. Good to see you as well. Thanks for coming down.
That was a nice distraction.
That was very nice.
By the way, you all are welcome to stay for the next couple few hours if you'd like.
As they grab their purses.
Trying to quit.
Yeah. They got a better deal. That was very nice.
I'll wait just a second. We're okay.
Bye, Karen.
It was very nice to go there. State photographer, that was all very
I don't know
nice.
who did that. Caitlin must have done that.
Caitlin, did you get the photographer? That was so
Thank
nice.
you.
So nice.
Yeah, and I'm hoping to maybe put it in the newsletter.
Oh, that's great. Oh, yeah.
Wait just 1 second till Mr. Wood gets here and we'll get going.
Five-year-old picture made.
Has he got sandals?
No, he's got on just loafers.
Just low.
Just loafers.
Where was those Franklin? That's
These are
from
my
your
house.
Yeah.
Yeah, that's Brianna.
Everybody's happy.
Saturday he tests for his brown belt. That'll be his 7th or 8th belt. One day I put my hands on his shoulders and all of a sudden, and did that and nearly broke me.
Oh my gosh.
I'm like, don't ever use that on your yah-yah.
Correct.
Roddy and his yah-yah.
3, 4. Where'd Rick go?
Hi. Where's Rick? He's
Where'd Rick go? Did you pass him in the... Oh, he's back here. He's back here.
And I just need to pull back from it.
That's what I got.
All right, ladies and
Everybody came
gentlemen,
for it, too.
Yes, that was nice.
let's get back to business. I'm going to adjust the agenda slightly and go to our informal appearance category. And I don't know, Caitlin, do you want to tell us what's in front of us, or does legal need to tell us what's in front of us at this point?
So before we do the informal appearance, what I was mentioning to you before, I actually need a vote from you guys before we can proceed. If you would like, once I present the facts to you, for this individual to proceed with the licensure.
So do we
Process.
need to vote to put it on the agenda? Is that the first vote, or is it a...
No, the informal appearance is on the agenda, so the vote is whether or not this individual that I present to you once the facts is allowed to proceed with the licensure process.
So
Being come
how will
before
we
you.
know that until we talk to the applicant or broker?
I just want the vote to be able to, so because of the Fresh Start Act, we have to make a vote. You have to make a determination whether or not the individual can come before you for an informal appearance.
All right, I got that. So we have an applicant here who does not meet our previous guidelines.
Yes.
Okay. And so is this commission willing to waive the rule in this case to hear the situation?
Move to approve.
I've got a motion by Ms. Franks that says that, yes, let's go forward with this,
Second.
and it was seconded by Ms. Hills. Is there discussion? All in favor of that motion, vote aye.
Aye.
Those opposed, no. That motion passes, and Ms. Matlock, we're free to proceed, right?
Yes.
Ms. Maxwell.
If Miss Anderson could please come up with her principal broker.
I-
You're going to swear them in? Yes.
The law director is going to ask you two to swear to tell the truth. If you will, just for the record, identify yourselves, because we don't have anybody's name in front of us. You sit there in front of that microphone and get used to talking into it, okay?
It's weird. That's okay.
What's your first name?
I'm Heather.
Heather Anderson, right?
Yes.
Okay. And sir?
I'm George.
You're not talking loud enough, George.
George Edrington.
Edrington, okay. Now, Caitlin, will you give some background?
Yes. Before you, we have applicant Heather Anderson and her principal broker, George Edrington. Ms. Anderson has taken and passed the Tennessee Affiliate Brokers exam. Her principal broker, George Edrington, was first licensed as an affiliate in March of 2004 and as a broker on 12/27/2017. He is currently the principal broker of Berkshire Hathaway Home Services. Mr. Edrington is responsible for supervising affiliate and broker licensees, and there have been no disciplinary sanctions. A summary of the disciplinary sanction is felony cocaine possession, and Ms. Anderson has completed her sentencing and has finished her probation, and her statement can be found on the iPads.
All right, Ms. Anderson and Mr. Edrington, here's how this works. So we're going to ask you, Ms. Anderson, to tell us anything you want to know, anything you want us to know about what happened, why it happened, what you've been doing since then, anything you think might be helpful to your case. Then commissioners will have the opportunity to ask you questions. Once we're done with you, then we're going to go to the proposed principal broker, let him tell us why he's interested in having you affiliate with his firm, and commissioners can ask him any questions that they would like to ask. And we try to keep it in order, but sometimes it gets out of order, all right? But the key issue at this point is for you to tell us what you think, what happened, what you think we need to know, what you are, who you are today, those kind of things. So you've got the mic, and there's no time limit.
What is that buzz?
Sure. That could be
You hear a
dangerous.
buzz going on? Okay.
So, all of this happened 10 years ago. It was in 2008. I was in my mid-20s. I was definitely a person not really thinking about consequences to actions or anything of that sort. And 10 years since anything like that's happened, there's all the people that I was with then, all the way down to my husband, my friends, my job, everything has completely changed. Anything that had to do with that kind of life is gone. I've remarried. We've got 5 kids at home that we set an example for. Everything is different. In a decade, someone can grow up quite a bit.
Tell us what happened, or you choose,
Yes,
prefer
I can do
not
that.
to.
No, I can.
It's your option.
I was pulled over in 2008, and underneath the passenger side car or passenger side seat of the vehicle, there was a small bag of cocaine that had .007 grams inside of it. Story of my ex-husband having the car the weekend prior to that and going to Ohio, but I don't think any of that matters. I was still in Georgia is where I got pulled over at, and there is a zero tolerance there. So any drug possession is automatically a felony.
Commissioners?
If I were to see a bag, I'm not real astute. How much is 0.007 of a gram.
It is literally just enough to test. It's like a dusting. I couldn't show you how much that would be because you wouldn't be able to see it from there.
Matlock.
Yes.
Ms. Maxwell. So this occurred 10 years ago.
Yes.
Typically, it would not come in front of us, right?
Correct.
Except,
Well, so there's a 10-year look back, and we look at the offense date. So the offense judgment date is February 25th, 2010. That's within the 10 years provision, and this is a felony, so they would come before for an informal appearance.
Well, it was 8 years ago, not 10.
It was 10 years ago that I got arrested, and it was 8 years ago that there was a judgment was passed.
Yes.
that's why we're here.
This is why it's coming before here, and I just wanted to point out as well, I was going to mention this before, one of the part of her sentence was 10-year probation, but in accordance with Georgia's first offender. And so Ms. Anderson completed that on August 8th, 2018. So actually she completed it 2 years early. And with that, a first offender law, she has the ability to have her record sealed after this, and that paperwork has already been submitted. So it's just the timing that this worked out in the licensure process why.
Yeah,
but
with the first offender law, the way Georgia does it, it's kind of like the Fresh Start here is once you complete all of your probation and classes or fines or anything like that you have, you no longer have a conviction. They will put it on a sealed record in case you ever get in trouble again. You can't be granted the first offender more than.
So we're here today because probation is not, it's been less than 2 years since probation ended.
And this is
Less than a month.
Well, it's less than 2 years, right?
It's the 2 years part, and it's the 10-year look back because of the judgment date. It's 8 years, not 10.
So this related to the Fresh Start legislation because normally our rule says we can't even consider it until 2 years after probation has expired or ended.
Correct.
So that's why.
Yes.
So that's why that law is part of this as well.
Yes.
All right, Ms. Anderson, anything else you want us to know about your situation right now? Ms. Franks.
So, so your probation, you petitioned the court for an early termination of that probation. Is that correct? And so, what did you base that on? How do you get early? How do you get off of is it probation? Yeah, early.
Yeah, so in October, I actually went on to a non-report status. Means, I didn't report to anybody or do anything at that point. After a time period on that, I have good behavior. I've not been in any sort of trouble. So I petitioned the court and I asked them, and they granted. If they say if there's no need to.
Questions? If not, Mr. Edrington, why are you interested in having this lady affiliate with your firm? Get to that microphone.
I'm so sorry. She came to one of our mentors, March, April, with a desire to become a realtor. We put her on a mentor process education that we do for all of our agents, and that's our discovery period too. We want to make sure that it's a fit and that they're going to honor what we consider our code of ethics to the consumer. And she's mastered that and finished all of her classes, education, done a lot of non-licensed activities for us, and done them expertly. So we're excited about her. She's since remarried, has 5 children. She's really one of us, and we've long, after we heard the story and got to experience her work ethic, we're way past that. Don't even think about it anymore.
All right, Commissioners, any questions for either party? Ms. Franks.
So, how long have you been a principal broker?
2017.
The first part?
Yeah, I've been a realtor for 14 years.
Oh, okay, I see here, 1227.
Right, and then we recently were awarded a franchise with Berkshire Hathaway, and so my family, it's my wife, my 2 sons, and myself, moved our group over to a new franchise, and so That's when my wife and I are both brokers. So.
And so you've had your principal broker's license for 8 months. How long did you have a broker's license before that?
No.
So how long were you affiliate?
14 years.
14 years.
Yeah.
And how many agents do you supervise? 39. So could you tell us a little bit about what you're going to be doing as far as training her for the position, or do you feel like from this mentor program she's already trained? Or
We have ongoing continuous education. I attend those classes.
Yeah.
We absolutely are dedicated to. My son, for example, is on the ethics board at our association. So we're very active, involved in our community and our association. And so everybody has to attend 2 days a week of continuous ed forever and ever and ever. Then every one of our affiliates are assigned to a mentor. So not only do they answer to my son, who's our CEO, okay, and I have to say yes, sir, to him. That's a new experience for me, okay. But they have to. My son does one-on-ones with the mentors and with the affiliates every month, everybody. So there's not much that gets past us, and we've had that life experience with our past broker where we saw some things being loosey-goosey. They've got a license, there's a desk, there's a cube, have a nice day. Nobody in our brokerage has that freedom. So we know exactly what's happening, and we've had to terminate a few that don't see eye to eye with how we conduct our business. But I can assure this commission that nobody in our firm gets past us with anything. But to take it back to Heather's, though, her family, her mentors here, we're behind her 1,000%. We've long forgiven it. We all got a skeleton or two probably somewhere, but after 10 years and watching her activity and her work as a non-licensed person in our company, we don't have any doubt whatsoever she'll be a stellar agent.
So I actually, and Heather knows I did this because she invited me to like her page on Facebook. I went to her Facebook page. One of the gentlemen that's not here, one of our commissioners, Mr. McMullen, I started to say Macmillan, is not here today, but he typically, he will be setting up here and he'll be looking up everybody on Facebook, LinkedIn, and that kind of thing. And so I thought, well, I'm going to look at that. And she has on her Facebook page, it says services, real estate agent, here for selling your current home or finding and buying your perfect home. And I think that's something that may have gotten past you as the principal broker, and maybe because you've not been a principal broker too long. And then also on her LinkedIn page, she says it had previous to your company that she was an agent at Keller Williams. And so I don't have any opposition to her not getting her license today, but I would say to you as the principal broker, be very careful about Facebook and LinkedIn because we get a lot of problems and complaints from those places. And she obviously didn't know any better, or she wouldn't have put it on there, nor would she invited me to like her page. And that's why I didn't like your page yet, because I knew you were coming in, and I didn't want to.
Might have a conflict.
I might have a conflict.
When this came before me and I was preparing myself, I also saw that, and her mentor and I have already had discussions. Correct? Yeah. Okay. So we've corrected that error, and at a couple other errors we found too. Okay. So, but it was a learning experience for us. We always have a process, but we also have a process improvement. So I'm glad you brought that up because it's been discussed with the mentor, and that doesn't happen anymore. Okay.
And a lot of times it's not discovered by Facebook friends, it's discovered by anonymous licensees who like to turn those things in. Yeah. Heather, anything else you want to add? That's a smart move because I sense we're ready for a motion. Is there a motion?
I'd like to make a motion that we approve Heather's application.
Second. I have a motion by Ms. Frank, seconded by Mr. Douglas, that Ms. Anderson be allowed to continue on in her process of becoming a licensed real estate agent in Tennessee. Further discussion. Let's vote. Those in favor of that motion vote aye. Aye. Those opposed, no. That motion passes unanimously. Best of luck to you. Thanks for coming down. All right, let's go back to commission discussions. Arello, you wanted to mention something about Arello, Ms. Franks?
Yes, I'm going to be co-chairing the Best Practices Roundtable this year at Arello, and that meeting is in September, and Mr. Douglas and I are going along with Ms. Maxwell and Ms. Matlock. You are going, right? The roundtable, for those of you who have not been there, it's nearly every person will be coming into this roundtable discussion, and we just throw out topics about what's happening in your state and what are the problems that are happening in your state. I've written down a couple of things like advance commissions and title companies writing commission checks. And some other things, but I just wanted to let you know if there's anything that y'all would like to have any questions about or discussions about. If y'all could just, hey, Marcia, I thought of this. Maybe you could talk about this at Arello. I wasn't sure until this morning that Rick was going, but I'm glad that he's going.
Is that it?
Yes.
All right, next up is you wanted some information or to discuss the October meeting.
Yes.
So you've got the floor.
Yeah,
Ms.
I
Frank.
just wondered, where it's in, where is it? I haven't heard any information.
Some phantom town called Gray.
Gray?
Gray.
So I
That's where the association.
I had put, I was going to mention it on my report as well, but reservations have been made for everyone at the Marriott in Johnson City. And so I was just going to do a little plug on my report as well. I think some of us have experienced this, but Marriott is now doing a 48 cancellation. So if for some reason you aren't going to be there on Wednesday night, I believe it's Wednesday the 10th, October 10th, that is. Oh, okay, the 3rd.
So, yes, the 3rd.
Oh, yeah, okay, right here. Guest accommodations over October 3rd. So if you aren't going to be there, let me know. And if you would like to stay the second night based on how far of a travel you have to make afterwards, Fontaine, I already got you. Let me know. And then I can send out the location of the meeting for everyone. But Diane, it's at the...
It's in the Education Center in Kingsport. Mm-hmm.
Is it one? You said come Wednesday, and then the meeting's going to be on Thursday?
On Thursday, yes, and it's only a one-day meeting.
Okay.
So we will not be meeting Friday. Our next scheduled formal hearing is for November. Scheduled being the key word.
Scheduled it. Robin?
Robin.
That's a bogus.
The one that's scheduled for November was the one that was continued from last month. And is there anything else?
Johnson City just right outside of Kingsport?
Just across the highway.
It's 15 or 20 minutes.
Okay.
Yeah.
So if we start at 8:30, will we start at 8:30 up there, or is that too early for people in Upper East Tennessee?
Well, that's not too early. Maybe too early. Well, I have a time frame issue.
Yeah.
Well,
I'd rather be able to get out and drive in the
Right.
daylight. I can't drive in the dark. Good.
Uh-huh.
all right, so it'll start at 8:30 unless, well, let's just say we're going to start at 8:30. Anything else? All right. So let's talk about your report.
So unfortunately, I do not have the complaint numbers for you this month with us meeting early and being off on Monday. I reached out and I should get those later today. So I will make sure to email those to everyone so you know the number of complaints that were opened this past month and those that were closed. I did get the financials at the last minute, which is why I provided everybody a printout. And I went ahead and gave you June but then, I'm sorry, July, but then also the previous fiscal year. And just a couple notes. There's one number on here that is incorrect, the state reg fee. That should actually be, that was a calculation error and should actually be close to $20,000 rather than the $2,000 that's listed on there.
Plus or minus.
It totaled $20,000 rather.
Like a negative $2,000.
Yes.
It should be a plus 20,000.
It should be a total of, it should be times 10.
Revenue goes up.
And so then the net surplus should be, / deficit should be closer to $60,000 rather than the 78 that's listed there. And then a couple other notes. I know last month there were some questions about the legal cost backs. Those have gone down slightly this month. But as I mentioned last month, I think around February we switched to hourly billing. I guess it was maybe around January. And so we are going to continue to watch that number, but I just wanted to note that those numbers will fluctuate months that we have formal hearings or months that we have any kind of hearings. And then I also wanted to note that they've broken out complaints now. That had previously been included in admin costs back. And so that cost is associated with the staff that processes all of our complaints. They're attempting to do more transparent billing, and that way we can see the line item of how much we're being charged for that.
Questions about that?
So, what's the status of getting an investigator? I mean,
an auditor?
An auditor.
So she started on Monday, or Tuesday, I mean, and I would like to have her come down and meet everyone maybe at our next break. I intended to have her come down at the first break, and it just ended up being a little bit, but I would like to have her come down. Her name's Michelle, and she started on Tuesday, and we already have a big workload for her. So,
was the gentleman before her able to close all the files that he had opened, or has she got those continuing over to her?
So actually, the ones that were left open, I worked with our director of the contractors board, and she loaned me a staff member that has assisted with closing those out.
And so they were all closed out when he left. After he left, that person helped you close out all those files.
Yes, yeah, they've been.
So this person's starting new on Tuesday with no
They're
files.
starting new. There might be one or two because the auditor that assisted me ended up needing additional documentation, so there was some back and forth between him and the firm. So I think he still has a couple that he's closing out, but I think the plan is for him to continue working on those because he's already started them, and then the new auditor to start fresh.
And so will the new auditor use the same system that the last one used?
I think in the beginning, we are having a sort of a roundtable meeting next Monday. And I think in the beginning, but I'm sure like anything else, she will go over the process and make adjustments where she sees fit.
Do you have any idea how many of those a month that they're opening?
I do. I don't know that I want to say that on the record because it is it's a random audit, but there is a certain percentage that they are selecting every month. And I believe that it's in line with the typical audits per the percentage that they're selecting for the year versus the number of firms that are opened.
So in that it's random, I was audited this past spring. So will I be audited? Does my name go out of the bowl, or does it stay in and I could be audited again next month?
Oh, it stays in the bowl. So they use a program. It's a random selection program, and they pull a list of all active firms, and then that program helps them to select a random selection from that full list. With that being said, though, I think we've seen this a lot lately. If we get a complaint that appears that, a firm, the complaint is related to the way they're handling their money or how they're keeping their funds, we have sent those out for a request for investigation, and then once the documents are received, they can be audited then as well.
So when I talk to other firms, some of them say, "Do we not get audited anymore? I haven't been audited in years." I don't like the idea that I could be audited again this year and that person not be audited at all. It seems like something's wrong with the system there, if that's possible. I would say this: can you have a rule that if somebody's been audited in the last year or 2 years, go to the next person, or what? Because some people are not being audited at all. And
I
can
could
see how
bring
that
that
could be a
back.
problem.
I do know that they want to keep it as random as possible without really manipulating the data, but I could bring that back and have an update for you next month.
I think it would be a waste of time of the auditors and the person that's having to go through it too, because I have a small company, but when I was doing it, I thought, man, these people with big companies, I don't know how they do it. So it'd be I'd hate to especially see a big company have to go through it.
More than.
Yeah. Okay, that's all.
Any other questions for Caitlin? Anything else for us on your report?
Nope, not right now. I'll send the complaint numbers as soon as I get those and get them organized for you guys.
All right.
Yeah.
How are we on personnel? Are you fully staffed now?
Yes.
Okay.
Yes.
What about when will the next newsletter be?
Middle of September. And I had a list of topics that I was already planning to include. I guess I should go ahead and mention this. As Ross mentioned earlier, we're working right now to get the education renewal notices out. We really wanted them to go online, and they could have gone online, but the way that it would have worked, I don't think we would have gotten many providers to do it online because it wasn't in a way that was convenient for them. And I'll just mention, the provider would have had to pay for each course separately. They wouldn't have been able to do one blanket payment. So a provider that had 100 courses would have had to pay at least $25 for each course 100 times. So we have put in with IT, that's an enhancement, essentially a contract change to have what they call shopping cart included, which would allow one licensee or the provider to pay for all of those in one lump sum. So when we figured out that's not going to happen before September, we sort of moved towards what is the next best thing that we can do with renewal notices. And so we've worked with IT to where each provider will get a full table of their courses. So it should be very clear as to which courses they would like to renew and the price for each course. And they should be able to just check the box and send it back to us. And then we have coded each application so that our fiscal department, when it comes in, they know exactly where to apply the money and they know exactly what courses that provider wants to renew. And then we're also gearing up for E&O. A large portion of licensees' policy expires at the beginning of next year. And so we are gearing up for that right now, getting additional staff cross-trained on how to do that. We've met with IT to make sure that they're aware that starting probably in October, we're going to be getting a large influx of policy renewals. And that system works very similar to the education renewals or the education courses where either the education provider or the E&O provider sends us a spreadsheet of the licensees that they would like to renew. It has their new policy number. It has their new expiration dates. That spreadsheet is then run in our system and uploaded and applied to each licensee's file. The issues that we run into is somebody goes by a nickname and we need the file to match exactly how their name is listed in our system. But we get a report of any errors, and then we can go back and fix those. But those are some of the things that I'd like to include in the September newsletter, just reminding licensees that those are both coming up. And then I've taken notes of the additional items that have been mentioned today.
We be having any rulemaking hearings? We used to do them in every January. We don't have any.
I don't think we have.
Okay.
The fee change rules that we made just now made it to the governor's office. Is that correct?
They've been approved by the governor's office and were sent for signature to the AG's office today. We do not have any rulemaking hearings scheduled for January.
And are you doing any outreach?
So right now, the outreach that has been planned has been in coordinates with travel that's already planned. So I know I had reached out to the association in East Tennessee to see if their licensees would want an outreach prior to the meeting. So it's been in coordination with travel. We are working, it's on my to-do list to revamp the outreach presentation and get that approved by legal and all other parties, and then sort of coordinate based on sort of travel rather than, driving 2 hours to present for an hour and back and that sort of thing.
Thank you.
Yep.
All right, other questions? If not, it's my distinct pleasure to ask Ms. Bridges and Ms. Smith to come to the front.
Did we do the auction task force?
Excuse me, I missed that. Please come up here. We have a report from Commissioner Wood, who's our liaison to an auction task force. Mr. Wood, your report, please.
Yes, I thank the commission for putting me on that task force. I think about you quite often while I'm sitting in those meetings.
Yes.
And but no, it's interesting. The auction task force, they've basically been put together to basically look at all the rules pertaining to auctions and to see if they want to put together any changes that they'd like to send to the legislature to take a look at. We look at auctions as real estate, and that's kind of our touch with auctions. But within that room, they have different people. We meet in here because it deals with auto auctioneers are in it, and then there's also personal goods, personal items auctioneers, and so they all do different things, and but it's really, it's interesting, but you've got factions, and there were some big changes made to the auction rules. I believe it's in 2006, and that is eBay. Basically is what it referred to, and that technically those are auctions, and then prior to 2006 you have to have an auctioneer to auction anything, and so of course in eBay there is no auctioneer. And so they made distinctions between timed auctions and untimed auctions, or timed auctions like in eBay situation. It's timed auctions that it has a definitive ending date or ending time. That's it. And it's been determined you do not have to have an auctioneer for that. But then if you go changing the ending time, then you actually have to have an auctioneer, and there's some battle over that. And so really the first thing that we're trying to do is define what is an auction, which is really, it's taken a lot of time. So there's not been a whole lot that they'd agreed upon right now. We were in our last meeting, and I said, I feel like we're just taking a beach ball and battling back and forth and not doing anything. And they said, yeah, that's what we are doing. I said, can we agree on anything? Let's just agree on something. And they did agree. It's
good to have a leader.
Well, that's not me. I'm still trying to figure out what's going on. They agreed to not require, when they have auction advertising, they had to put their auction firm number on everything. And so we agreed to not require that anymore. That's what we've agreed on. But the battle is, about apprentice auctioneers. And then I think there's going to be some concession made on apprentice auctioneer, time done. And so it's kind of like they're rewriting the whole auction rules from the beginning. But we're not even in agreement what auction means yet. So there's some time on this.
Go ahead.
So, and and I'm trying to think of the name. So we've seen once in a while in our area, it's like auction.com or something. So a listing will come through MLS, and the licensee is clearly not an auctioneer, and the company is not an auctioneer company that has it listed, and then and you, it's been a long time since I've looked at it, but it still comes through. But in the remarks, that's how you put your bid in on this property. So is that auction?
I don't know that I specifically looked at that one, but that's what this task force is looking at. I mean, what is an auction? What's not an auction? I mean, in Middle Tennessee, we just had a recent situation where a listing agent decided to conduct an auction. I mean, literally put out, this is our starting bid. When we ever get our final offers looked at, then we will determine if that's acceptable because the seller has a reserve. I mean, it checked all the boxes, auction, 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 but this person was not an auctioneer.
And this shows other people's bids, as if you were there in public. It would show so if you go to submit a bid, you see what the high bid is and things like
eBay.
that. Yeah.
Yeah.
So this promise that this would just be a small portion of your professional life is coming true? Is it?
No, I don't think so.
These conference calls, or
no. We're physically here. So
we appreciate your service.
Yeah,
we sure do.
It'll be interesting. I mean, I mean, you think about that. If we had to get together and get a bunch of people together and basically determine what is a real estate transaction, that's where they are right now. So
I think long term it'll be good for your teaching career.
I'll have stories.
That's exactly right. All right. So, Ms. Bridges, we'll start with you. Would you mind reading the case numbers 1 through 20 into the record, and we'll see if any commissioner wants to pull.
All right,
one or
sounds
more
good.
out.
Number 1 is 2018-020721. Number 2 is 2018-026421. Number 3 is 2018-026391. Number 4 is 2018-026431. Number 5 is 2018-027441. Number 6 is 2018-027971. Number 7 is 2018-028051. Number 8 is 2018-028111. Number 9 is 2018-027831. Number 10 is 2018-028771. Number 11 is 2018-029141. Number 12 is 2018-029341. 13 is 2018-029361. 14, 2018-029931. 15 is 2018-031321. Number 16 is 2018-031621. 17 is 2018-031601. 18 is 2018-031641. 19 is 2018-031401. And number 20 is 2018-032091.
Thank you, commissioners. Would you like to pull any of those first 20 cases out for discussion?
I'd like to pull number 1 out.
All right. Any others?
Yes, 15, 16, 17, 18.
All right. Commissioners, anything else? I think I'd like to pull out number 11, just for a quick discussion on that. All right, if that's it, is there a motion to approve cases 1 through, a motion to approve council's recommendation on cases 1 through 20 with the exception of 1, 11, 15, 16, 17, and 18? Motion by Mr. Wood, seconded by Ms. Taylor. Discussion, all in favor of that motion vote aye.
Aye.
Those opposed no. That motion passes unanimously. All right, number 1, Marcia, what's your issue there?
Hey, I'm wanting to know, is there a law that you have 21 days to return earnest money funds?
Don't believe it says specifically 21 days. I think it says reasonable time.
Oh.
It may say 20. I need to double check that. Is it 21 days?
I'm sorry. If you look at 1260, 0209 9 in your rule book.
Does say 21 days.
Is that not speaking specifically towards interpleader actions? As opposed to...
But it's 21 days from the time somebody makes demand for the payment, for the money. It's not exactly 21 days when the contract expires.
Of a written request
Yeah.
for the disbursement.
Yeah.
Okay. Okay.
You okay?
That's fine.
You want to make a motion?
I'll
to
make a
approve?
motion that we dismiss this one.
All right, motion by Mr.
Second.
Frank, second by Mr. Wood. The case number 1 be dismissed per council's recommendation. Those in favor, Ms. Taylor.
Oh, no, go ahead.
Those in favor of that motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Ms. Taylor.
I just want to make a comment, Kelsey. At the first, you missed in several of these who these people against in the first line. It says complainant was a potential, well, it does say it there. But in several of them, I think that, well, it don't look like. I made myself a note that we're missing, and it may be somebody else's, that we're not finding out on the first line who people are.
I did make an effort to make sure that information was included.
And I wrote my note, but it might have not been you. Okay, so I'm just saying that.
All right, thank you, Ms. Taylor. I think Ms. Taylor just wants to reiterate the point that is helpful for us to know who the players are initially.
And also, if we could get the pages numbered, that would be a great help. Thank you.
Number 11, I asked this to be pulled out and only have the next to the last paragraph on this narrative. It talks about this broker. This is about a broker who continues to send emails to a property owner even after he finds out the property is listed with somebody else. And that next to last sentence says, respondent states they only meant to offer complaint in their professional opinion that the listing price was too low and that they were not trying to interfere with the other agent's representation agreement.
I marked that.
Is that
interesting?
Is that a statute, though, or ethical?
I just thought I'd mention it.
Okay.
But I don't believe that statement. Let me just say that. I think it's somebody ticked off because they don't have the listing.
Mm-hmm.
And I don't know.
Yeah.
Mm-hmm. I don't know if that has anything to do with anything, but at this point, now that I've said that, I'd like to make a motion that we accept council's recommendation and adopt dismiss number 11.
Second.
All right, other discussion? Those in favor of that motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. 15, 16, 17, and 18. Are they all related, Diane?
The way I figure it, they are. I was
Yes,
doing
they are all
anonymous.
on like the first one or two, unconfused, and then when I got to the then I got to number 17. That made me reread 15 and 16 because number 17 was an affiliate broker whose license was suspended, but the respondent is the owner of this corporation.
Yes.
So we have someone who had a license, had their license suspended, and I want to understand what kind of company this is. What is their business? Do they sell fruits? Do they have a fruit stand and they're just selling something that they own, real estate that they own? What's their business?
They're a redevelopment company. That's how it was described in one of the respondents' answers. And according to all 4 respondents, they state that their corporation buys homes, they sell those homes, occasionally rent them, sometimes flip them. But in any event, any property that they sell is either owned by the corporation or it is listed by a licensed real estate broker who does also happen to be employed by this corporation.
So why do you employ? Why does an owner who's had their license suspended employ another realtor who, I think it said, hangs their real estate license at another at a real estate firm somewhere else? that
I
right?
couldn't tell you specifically why they chose to hire that individual. It appears to me that they wanted to, I would assume, I think this is speculation, but I would assume that they wanted to have a licensee on staff to ensure that they are in compliance, and so that any listings somehow they did obtain, if for some reason that company didn't own them, they would not be the party selling them.
Okay, so we've talked about the LLCs and what they can do, and the Attorney General's opinion. How many employees are there? And do they all do this? Do they all sell real estate that the company owns?
I don't know how many employees are there. I took a look at their, About Us section, and I want to say off the top of my head, maybe there were 10 people listed under their staff. I know in one of these cases, the respondent says that his primary job was to answer phones and to occasionally assist with managing rental properties. But I don't know how many people are involved exactly.
And there's nothing that's standing out to seem like this is a real estate company. They're selling real estate. I'm working there without a license, and I'm selling property I don't own.
Well, in this case, I could not find any evidence that they are, in fact, selling property that they don't own. And there is a clear exemption.
Individually, the worker.
That the corporation does not own.
So I thought, so let's say a hospital, commercially. So there's a hospital, and they have a department that they could then, I thought it would say, I'm appointing you to be the one to liquidate our property. We've merged, we have some extra properties we've got to liquidate. So I thought the owner or the board of directors or something could assign someone to do that, and I thought that's legal.
As long as they're licensed.
Well, why is that any different from this? And then I read what is stated, that they state is how they're complying. What was it? 6213-104, is that what they said?
Yes, it's 104A1F establishes the corporation exemption.
It is a corporation, not an LLC.
Not an LLC.
This is a corporation.
S-corp, I think I said, and that's considered a corporation?
Yes.
Okay.
So,
The way I read it, I think they've read the statute, they've read the Attorney General's opinion, and they were checking all the boxes. That's what I got the feeling.
And I will add, I did pull a couple of the listings on their website randomly to see if, in fact, the corporation currently owns them, and they do.
So 6213-104A1F talks about corporation on page 10. Through an officer duly authorized to engage. So see, that's my scenario that I picture, like with a hospital or something that's not doing business in real estate, but they can assign an officer, so assign someone that's an employee to do this. But to lease or to manage or something, they're real estate that they own. So this is, the whole company gets to do it. To me it sounds like it's a real estate company. I can't, I'm missing it.
Well, if you go back to that exemption for corporations, it's pretty wide exemption.
It is.
So if a corporation wants to sell its own real estate, and they have an employee who works on staff at that corporation, they can put that person in charge of answering phone calls about that property.
Yes.
So that statute, though, 6213-104, that they have pointed out that they are complying with, says exemption dash firm licensees for vacation lodging service. Is that just for vacation lodging service, or is that for everybody?
No, ma'am, it's not just for it's for everyone.
Okay.
The way I got the feeling, this corporation was no different than the hospital that you described. It's just a lot smaller.
So do they take escrow money? Do they take the public's money?
They don't call it escrow money. They might call it a building deposit or security deposit.
So it's a building. So why wouldn't the builders do this? Why wouldn't the builders
It all
do
depends.
this and then hire people to sit out at their sites and stuff?
Well, I think the biggest thing is most people don't have corporations anymore. They have LLCs. Right. So this is probably some of the older companies. My husband's company is so old, it is a corporation. Franklin Realtors is in the same office with Enterprise Construction. So we have the same person answering the phone for both companies. But I didn't know about the LLC thing until our first meeting that I had here 5 years ago. And at that point, because this new company he had was a LLC, then everything had to go through Franklin Realtors versus he was, going out making his own deals. And thought he could because he was a corporation. Well, he wasn't one company, but the one he was purchasing in was an LLC. So that's when the real estate company had to step in. So you can have, in a corporation, you can have an employee that's not licensed to do this.
All the employees? Because to me, it just
I don't know
sounds
if it's
like it's
all
a
the
real estate
employees.
company.
They're only dealing in their own inventory.
Right.
It just seems not.
It's because they're a corporation that they can.
It's a technicality.
Yeah.
So on 6213-301, which is the license requirement on page 30, the corporation trumps that requirement to have a license.
Yes, because they would be exempted from obtaining a license under 104. That's in the third line from the bottom or so of that 301.
Page.
On page 30,
Part 3, qualifications and licensing. You got it right here.
The third sentence from the bottom.
Let me read it to you. Like my husband. It's just a technicality and that's the reason it has to be dismissed.
And so they don't have to disclose to the public or anything like licensees do?
the one licensee involved as a respondent stated that they do inform where necessary that they are a licensee, and when I looked at their profile,
Is when appropriate. I'm not
well,
sure
and when
when.
I looked at the profile on the website, and it did disclose that they are a licensee.
So a licensee, so you're saying the licensees was on that company's website?
Yes.
As a licensee. But that's not where the licensee hangs their real estate license because it's not a real estate company.
Right. As far as I can tell, the licensee is not exactly acting in a licensee capacity in their employment for the corporation, but occasionally they do receive listings from the corporation, or rather the licensee's firm receives listings from the corporation.
So, but we know this is a corporation, it's not an LLC or...
Yes, and like I said, I did verify at random. I chose a couple of the listings, and they were all owned by the corporation.
But, I mean, we know it's a corporation. So
Yes.
when you went on state to be sure it's not a LLC.
Yes,
it's corporate. Okay, that's all.
You want to make a motion at this point, or you're
No
just
way.
frustrated enough that you
Just
don't want to be the
frustrated
one?
enough.
I will. I'll make the motion. We dismiss 15, 16, 17, 18.
Second. I have a motion by Mr. Wood, seconded by Ms. Franks, at 15, 16, 17, and 18 be dismissed per council's recommendation. Those in favor of that motion vote aye. Aye. Those opposed, no.
No.
That motion passes on a 5-aye and 1 no vote. All right, Ms. Smith. Oh, sorry. Let's go to Ms. Maxwell.
So
for a
I
second.
think I just missed it, and so I just want to make sure that we have it for our minutes. On number 11, that motion was made by and seconded by.
I pulled it out.
Yes.
I made the motion to dismiss, and it was seconded by Diane. If you will, Erica, read in 21 through 36 for the record.
1, 2018-022-961. 22, 2008.
Are you ill or anything? I just can barely hear you, so I was...
Oh, no, I'm not ill.
I just checking. I didn't want to ask an impertinent question. So
Now I'm embarrassed. No.
Use your cheerleader voice.
23, 2018-023-491. 24, 2018-023-541. 25, 2018-024-081. 26, 2018-024-161. 27, 2018-023-961. 28, 2018-025-081. 29, 2018-025-331. 30, 2018-026-741. 31, 2018-026-761. 32, 2018-023-981. 33, 2018-024-251. 34, 2018-025-571. 35, 2018-024-801. 36, 2018-027-301. That should be it.
So, first of all, an appropriate answer to my question would have been, no, are you deaf? Okay, I mean, that would have been an appropriate...
Yeah, I would never, ever say that.
Why? If I'm bold enough to ask you that question, you ought to be bold enough to give it back to me. All right, Commissioners, 21 through 36. Anybody want anything pulled out?
32.
32. Anything else? All right, then is there a motion to approve the council's recommendation and dismiss items 21 through 36 with the exception of item 32?
Motion to approve.
Motion by Ms.
Second.
Hill, seconded by Mr. Wood. Discussion. Those in favor of the motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Diane, number 32.
I just want to ask about the date. So it says first licensed 4/4/2018.
I was wondering about that too when
And
I
then
first saw this.
and open the complaint
9 days later.
9 days later. And then, so it's just a time frame in my head, of course. The second paragraph, respondent confirms complainant purchased timeshare interest, blah, 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 in 2016 and again in 2017, provided copies. So this person wasn't in timeshare before and came back, or they just got in the records? And
Based on the internal research I did in our licensing database, the respondent has been associated with, I guess, submitted an application as far back as 2012 and has been timeshare exempt. So I'm not really sure what the date.
well, I know what that code is. It's
April
6213-104 for timeshare.
Yeah,
exempt.
I'm not really sure what kind of license they have and they obtained on April 4th, but I know they have been timeshare exempt since 2012 as far as I can tell. And I'm wondering if that's why there's no expiration date. And Caitlin, can you shed any light on that?
I'll look it up now just to see what transpired, but timeshare exempts do not have an expiration date. They get licensed in our state based on licensure in another state, and they pay the one-time fee. A regular full timeshare registration renews every 2 years.
But they don't have to pay every 2 years?
No, a regular timeshare registration does have to pay every 2 years.
So somebody that's not in the state but can sell timeshares in the state doesn't have to renew its license.
I'd have to pull up the exact statute, but I think essentially they're registering for their timeshare that's located in another state that's not actually in our state.
I wrote on the front of mine, we have a timeshare problem. You know, so many of these that we are dismissing. I mean,
I'm going to make the case that we don't have a timeshare problem. We have people that are advertising. They can get people out of their timeshares, and they have a template to fill out. And so all of a sudden, BBB's mentioned all the time.
Right.
What do you guys have an opinion on that?
Yes, I think that is correct.
And we've had recently, and we had one today and probably 4 or 5 last month, that as soon as the complaint is filed, they get the refund.
Actually,
that happens often.
I was going to say, we met over the last month with the timeshare organization, and they are also seeing the same trend where a lot of the complaints and the responses all look very similar, just different information plugged in. And so it would appear that a lot of the complaints are coming from one of those organizations that a timeshare will get you out of your timeshare. And one of the groups that was in the meeting mentioned that they had previously been letting all these people out just based on the complaint, and they potentially are going to change their tactic because it seems like they're sort of feeding an industry.
So that sounds like something we should discuss at Arello.
That's a good point. Yeah. So who pulled out 32? Diane said, are you okay with it at this point?
So that falls under that same exemption that we just talked about.
The question was about dates more than the case, right?
Uh-huh.
I mean, I'm as far as I can tell, I know they are timeshare exempt, so I would think that it does fall under the exemption.
What are timeshares exempt from?
I've tried to educate myself on that, and I'm just a little bit confused about it because of the fact they have a license number with us, but they're timeshare exempt, and it shows they're active but uninsured. So I'm really not clear.
And I'm not an attorney, so this interpretation, just take it with a grain of salt. But my interpretation of the difference between a timeshare registration and a timeshare exempt is that a timeshare exempt is wholly located outside of our state. They're becoming licensed to come to our state to market or to present their timeshare, potentially at places like, Gatlinburg, where there's other timeshares. The sale of the timeshare is not taking place in our state, but the marketing of the timeshare that's located outside of our state, they're getting licensed to be able to market the timeshare that may be like in Florida or wherever it is. So they're essentially registering with us to be able to do that. A timeshare that is just regular license as a timeshare registration is located in our state. The sale of the timeshare is taking place in our state, if that makes sense.
And this respondent is located out of state. I do know that.
I make a motion we approve.
Second.
I have a motion by Ms. Hills, seconded by Ms. Franks, that council's recommendation be adopted and item number 32 be dismissed. Discussion. Those in favor of that motion vote aye.
Aye.
Those opposed, no. That motion passes unanimously. All right, that concludes the consent agenda, unless, ladies, you have anything else, any late cases. All right, let's get on to the legal report. Ms. Bridges.
And that's where my note was to put the people in.
All right, Kelsey, if you'll read this into the record.
Number 1 is 2018-025911. Complainant contracted to purchase a property in Mississippi. Respondent represented the property seller. Respondent is a licensed broker in both Mississippi and Tennessee. Complainant entered into a contract for the sale and purchase of real estate, which is a Mississippi Association of Realtors form, on February 20th, 2018. Complainant states that their agent was concerned that complainant would not be approved for a VA loan because the property complainant sought to purchase required extensive repairs. According to respondent, an appraiser inspected the property on February 27th. On March 1st, the appraisal was submitted with a value equaling the purchase price with an as-is clearance. Respondent states no repairs were needed for the loan to close per the appraiser and the lender. Respondent informed complainant's agent that complainant could select their preferred contractor to make improvements and modifications to the property. According to respondent, complainant's agent informed respondent they were getting estimates and accepting bids. On March 7th, complainant's agent contacted respondent via text asking if respondent could meet with the complainant and an electrician at the property. Respondent was unavailable but stated they would put a combination lock on the property for contractors and a termite inspector. On March 10th, respondent discovered that complainant was already in the process of making modifications after their client notified respondent that it appeared someone was occupying the property. On April 7th, complainant's agent notified respondent that complainant was terminating the transaction because they were unable to qualify for a loan due to a discrepancy with their income. Complainant acknowledges that they had already started modifying the property prior to closing. Nevertheless, they contend that they are owed $3,000 under the terms of the parties' purchase agreement as reimbursement for the cost of materials and improvements. This complaint was filed by a Tennessee resident against a Tennessee licensed broker. However, the transaction involved in this complaint was for a property located in Mississippi. Complainant's agent and respondent are both licensed in Tennessee and Mississippi. The sales documents are copyrighted Mississippi Association of Realtors forms and refer in part to Mississippi law. Counsel referred this matter to the Senior General Counsel for the Mississippi Real Estate Commission, who advised Mississippi is pursuing the matter. As such, counsel recommends the commission dismiss this complaint and flag respondent's license. And again, my recommendation is to dismiss and close and flag.
Move to accept counsel's recommendation.
Second.
Motion by Ms. Frank, second by Ms. Taylor, that council's recommendation be adopted, this complaint be closed and flagged. Mr. Wood.
Why are we flagging it? Why not just dismiss it?
We could dismiss it. I wanted to flag it just with a referral to legal so that we could check it out, especially depending on what Mississippi's decision winds up being. But flagging their license would not mean automatically refusing to renew or anything like that. It would just get sent our way to look at.
Okay.
Other questions? If not, let's vote. Those in favor of the motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Number 2.
All right, number 2 is 2018-025981. Respondent is the principal broker in the above related matter. Respondent states they agree with the actions of the affiliate broker and contends complainant breached the parties' agreement by entering the property and starting construction without the knowledge or consent of any other parties to the agreement. Counsel finds no evidence of a failure to supervise and recommends this matter be dismissed. Additionally, this matter has been forwarded to the Mississippi Real Estate Commission along with the above related complaint. My recommendation is to dismiss.
Motion to accept counsel's recommendation.
By Ms. Hill, second by Ms. Taylor, the council's recommendation be adopted and this complaint be dismissed. Discussion. Let's vote. Those in favor of that motion, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 3.
Number 3 is 2018-027181. Complainant is a licensee. Respondent is a principal broker. Complainant and respondent do not work at the same firm. Complainant alleges respondent maintains a separate office outside and adjacent to their firm's main office. Complainant alleges this office is fully functioning and the respondent is operating as a team without any sign or other indication that they are part of the main firm. Complainant also alleges respondent is acting as a principal broker without the proper license. Respondent states that they are a licensed principal broker and provided confirmation of their license status. Upon review of the Commission's internal records, it appears that as of receipt of the complaint, respondent was the principal broker for a licensed real estate firm and not acting as or working with a team, contrary to complainant's assertion. Counsel recommends this matter be dismissed. However, upon review of the complaint files and internal records, it appears that there may be other ongoing violations occurring at respondent's firm. Specifically, it appears there may be some brokers working out of respondent's firm without affiliation. Further, while respondent's license was in effect when this complaint was filed, research indicates that there may have been some advertising prior to respondent's receipt of their principal broker and real estate firm licenses. As such, counsel recommends the Commission authorize the opening of an administrative complaint to determine the full scope of these possible violations. My recommendation is to dismiss and open a new complaint to address concerns related to possible violations of Tennessee Code Annotated 301 and Section 310.
Move to accept
In the
counsel's
6213 trail.
Yeah, I
just wanna
did.
be sure.
Thank you.
Move to accept council's recommendation.
Second.
Motion by Mr. Wood, second by Ms. Hills, the council's recommendation be adopted. So, Kelsey, one quick question. So this guy's got a principal broker's license.
Yes.
Is there a firm at that address?
Yes.
Is there a firm license as well?
There is.
So that's not what you're looking into.
Right, but that's what the complaint raised, and that was what the respondent spoke towards. So that's why I wanted to open up a new one so that they would be given opportunity to address the specific violations that may be occurring.
Perfect, thank you.
And how did you find these other violations?
I actually cannot take credit for that. There was a note left from a previous attorney that said maybe we should look into these, just make a note in the file. And when I did look at it, I thought it looked a little suspicious.
All right, you've heard the motion. It's to accept council's recommendation. Other questions? Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 4.
All right, number 4 is 2018-027421. Complainant is a timeshare owner. Respondent is a licensed real estate firm and timeshare developer. Complainant executed a timeshare purchase agreement on April 9th while complainant was vacationing at respondent's resort. Complainant states that upon returning home, they decided to terminate the purchase and mailed respondent a rescission letter dated April 20th and postmarked on April 21st. Complainant received a phone call from respondent's principal broker on April 23rd, who informed complainant that they failed to exercise their right to rescind the agreement within 10 days and therefore their contract would remain in effect. Complainant states they never received an on-site inspection, therefore they had 15 days to rescind. Complainant further alleges that they only received 2 of 3 pages of the timeshare public offering statement. Respondent states complainant's claim that they never received an on-site inspection is without merit because complainant entered the agreement while they were staying at the timeshare resort. Respondent maintains that complainant had only 10 days to terminate the agreement and states they will not accept a late request to terminate. Respondent also provided a copy of the public offering statement, which includes complainant's initials on all 3 pages. However, counsel notes there is no provision in the public offering statement which purports to confirm complainant's receipt of the document. Following receipt of the respondent's answer to the complaint, counsel reached out to complainant to inquire about the alleged on-site inspection. Complainant informed counsel and provided documentation to show that while vacationing at the resort, they stayed in Building 3, Room 323B, whereas complainant contracted to purchase Room 114B in Building 1. Counsel finds complainant's stay at the resort in a completely separate unit and building insufficient to constitute an on-site inspection and recommends the Commission authorize discipline for respondent's refusal to honor the party's 15-day rescission period. Counsel also notes Tennessee Comprehensive Rules and Regulations 1260-06-.02, which requires a timeshare developer to obtain from a timeshare purchaser a signed and dated receipt for the public offering statement. My recommendation is for a $1,000 civil penalty for improper dealing pursuant to Tennessee Code Annotated 6632-121F2H, and a $500 civil penalty for respondent's failure to obtain a receipt for the public offering statement in violation of Rule 1260-06-.02.
Motion to accept council's recommendation.
I have a motion by Ms. Hill, second by Ms. Taylor, that council's recommendation be adopted. Questions?
So, and I can't say that I've really looked at this, but or looked at this timeshare law a lot, but the big discrepancy here is what is considered on-site.
Yes, and I will say I could not find any case law that goes into what constitutes an on-site inspection, but I would strongly contend that merely purchasing a room that is somewhat close to the room you are staying in would not constitute an on-site inspection. The fact of the matter is the purchaser never saw the unit that they purchased. Therefore, I don't think you could say that's an on-site inspection.
And they specifically bought that specific 114B.
Yes, it is identified in the purchase document.
Yeah, I mean, everybody vacations. One condo may not look like the next condo, that's for sure. So I would think that was not a...
Well, then I would just, and again, I'm just kind of thinking out loud. So let's say if they're building a building, then we're pre-selling them. Then in that situation, we would argue then there's no such thing as an on-site inspection because it's not built yet.
So everybody purchasing in that case would have 15 days to rescind.
I don't have a strong belief anyway. I just want to be consistent. I mean, we can play by the rules if we know what they are. I just want to be consistent.
Building something, you would inspect it just as it was finished, regardless, right?
Well, I guess you
already purchased it.
Yeah, you've already purchased it, I guess.
You don't close until it's finished.
Yeah, you can't close till it's
Yeah,
finished.
but not everybody will necessarily come back and look at it in a timeshare situation.
See, I'd make the argument that the timeshare, you're just buying air anyhow. You might get a deed to a specific unit, but it doesn't mean you get to use it that particular week. You get to use one of the units there, or in Tallahassee, or wherever it is.
I'm with John. I'm convinced. I don't think a lot of people buy it to stay in that unit.
It looks like these people did, though.
Well, they're using that for their argument right now.
One thing and you don't look at it, I think, to me, I'm very succinct on.
I understand. I struggle with timeshares, but in my mind, I picture people buying time as much as they're buying real estate.
We need both Anna and Caitlin to go to the timeshare meeting this year at Arello.
Well, let's
a ball of yarn that none of
See
us
fear
understand.
in their eyes.
All
right.
Passing judgment on it.
Let's do this. There are two recommendations for two different violations. Let's bifurcate those, and
look at you.
And let's take the first one. So, can I assume, Diane and Fontaine, that your motion on the first one is to accept council's recommendation, which is you'd made a motion to accept both of these?
I did, but I was looking at how it was broken up here. Proper deal.
I don't understand probably what I need to understand about timeshares, but so when these people purchase this timeshare, does that mean that every time they go to this resort or wherever it is, they're going to stay in this specific room?
That's the way I understand the purchase document. Now, if they were buying points, I think it would be different. But in this case, they specifically contracted for that unit in Building 1.
So, could the improper dealing is that they didn't have them sign the receipt for the public offering statement. So one, they didn't sign it and couldn't produce it, and the other is that's improper action.
I might vote different ways on these two.
Okay.
So that's why I've bifurcated the question.
I'll be willing to separate it.
Okay. So can I assume your motion on the first $1,000 recommendation is to approve council's recommendation?
Yes.
And Fontaine, that's your second, right?
That's what I said.
Okay, so let's vote on that motion first. Council recommends a $1,000 civil penalty for improper dealing pursuant to TCA 6232-121F2H. If you're in favor of that motion, please vote aye.
Aye.
If you're opposed, vote no. Chair votes no.
No.
Motion. Rick Douglas votes no, so the motion passes on a 4-2 vote. All right, next up is council's recommendation for a $500 civil penalty for respondent's failure to obtain a receipt for the public offering statement in violation of the stated regs. Are you okay with your motion, Diane, accepting council's recommendation? Okay, Fontaine seconds that. Is there discussion on that? If not, let's vote. Those in favor of that motion vote aye. Aye. Those opposed, no. That motion passes unanimously. All right, thank you for your indulgence on that. Let's go to number 5.
All right, number 5 is 2018-03040. This matter involves two complainants who formerly affiliated with respondent's firm. Respondent is a principal broker. Complainants left respondent's firm in May 2017 and January 2018, respectively, but respondent's firm still has billboard advertisements that feature complainants' names and likenesses. Complainants are concerned that their current clients will see these advertisements and attempt to reach them at the wrong firm. Respondent states they currently have billboards up that do not accurately represent their staff.
Respondent states these advertisements are under contract and can't be changed until the contracts expire. In the meantime, respondent states they spray painted over one of the advertisements so that it no longer features complainant number 1 and provided a mock-up of the advertisement that will replace the billboard which currently features complainant number 2. Counsel notes that respondent has taken some steps to correct their firm's advertisements, but it appears action was only taken upon receipt of the complaint. Further, respondent's answer indicates that at least one of the advertisements has been out of date for over 2 years. Counsel recommends disciplinary action be taken for misleading or untruthful advertising in violation of Rule 1260-02-.12, and my recommendation is for a $1,000 civil penalty.
Accept counsel's recommendation.
Second.
Motion by Ms. Taylor, seconded by Ms. Franks. Discussion.
Is there one advertisement or two?
2 advertisements.
One's been out of date for over 2 years, meaning somebody's been gone for over 2 years.
Yes.
See, this is just me, but the agents left the company. It wasn't, and this is not an advertisement selling real estate. It just happens to show collectively who was with the firm. I have a hard time thinking the principal broker or the owner is in charge of every time somebody comes or goes, they're in charge of changing the sign. That doesn't feel right to me at all.
So it's a group, like here's just like our group picture earlier, and
yes.
not just 2 people or something.
And it's a billboard. Yeah, a billboard. We've had billboards, and you're on a you rent them for so many, and they can be $10,000 a month. And if you want to change it, it's going to be very expensive. That's why they didn't do it, because of the expense of it.
I would pose the question, if the commission had deemed one of these billboards to be misleading or untruthful, not even these billboards, but any billboard, I don't believe the commission would accept the argument that, well, it costs $10,000 to change, so I can't take it down.
It's been going on for 2 years. Certainly you change your advertisement in 2 years.
Oh, yeah. Well, hey, not everybody does. No. There's a lot of them left up for years.
So if the sign company doesn't have a new one to take its spot, they just leave it up?
You could have the very
get
same
free.
thing put back up if you wanted the very same. I mean, it's just a matter of money. But if it's 2 years, I mean, I agree with the civil penalty.
Do we know if there's just pictures of the agents, or did it have their names on the billboard?
It had their name and their picture. There was not a phone number for the specific agents, just the firm's phone number.
Would be curious, do we know why the agents left the firm?
No, they didn't state that in the complaint.
The motion properly made is to accept counsel's recommendation and authorize a $1,000 civil penalty. Any other discussion? Let's vote on that motion. If you're in favor of the motion, vote aye.
Aye.
If you're opposed, vote no.
No.
Chair votes no as well. The motion passes on a 4 aye, 2 no vote. Number 6.
Number 6 is 2018-030011. Complainant was a potential property buyer and respondent was the property listing agent. Complainant states they submitted an offer and were told they were the first backup offer and that the first offerer had until April 26 to obtain proof of financing. Complainant states the offerer missed the deadline but received an extension of April 30th. On May 1st, complainant's agent received an email from respondent stating complainant was now the primary offeror. Complainant submitted their earnest money payment and began to make preparations for closing. Complainant states that shortly thereafter, respondent attempted to put complainant's offer on hold and quit responding to complainant's agent. Complainant states neither they nor their agent nor their attorney were able to contact respondent. Complainant states their agent finally received a message from respondent stating they would be available to talk on May 7th, but they did not follow through, and then on May 8th, complainant learned the sellers were closing with someone else. Complainant provided a copy of the TR purchase and sale agreement, which was bound on April 14th, 2018, and provided for a closing date of on or before May 25th. The agreement also provides that closing is contingent upon termination of an already existing primary offer for which proof of financing was still pending.
Note that on May 23rd, complainant submitted a request to withdraw their complaint. Complainant stated the parties, through legal counsel, reached a settlement agreement and that they are completely satisfied with the outcome. Respondent states they entered into a listing agreement with the property sellers on April 11th, 2018. On April 13th, the seller entered into a purchase and sale agreement with the first offeror for a sales price of $300,000. Per the terms of the agreement, the offeror had 14 days to obtain proof of financing. When the offeror failed to deliver their proof of financing by April 27th, the seller submitted a written demand and, per the terms of the agreement, provided the offeror with an additional 2 days. This occurred over a holiday weekend, so the offeror had until April 30th. The offeror still failed to meet the deadline and the agreement was terminated. Respondent states they received complainant's offer on April 14th. The seller accepted, subject to a standard TR form backup agreement contingency addendum. When the first offeror defaulted, respondent sent the notice of termination and informed complainant's agent that they thought complainant's offer had moved to the top and would send a notification signed by the sellers when they were sure. Later that day, respondent received an email from the first offeror's broker who contended the seller's written demand failed to specify a 2-day time frame and therefore the purchase and sale agreement was still valid. Respondent states they informed complainant's agent later that day that the first contract was in dispute and that they would have to put the notification on hold. Respondent's firm and the first offeror's agent thereafter entered into a legal dispute over the validity of the contract. Respondent states they received a message from complainant's agent inquiring about their status on May 2nd. Respondent consulted with their firm's lawyer, who advised that the first offeror's contract was no longer valid. However, shortly thereafter, they were contacted by an attorney for the offeror, who maintained their client still had a binding contract. Respondent states that around the same time, their client determined they wanted to go ahead and sell to the first offeror. Respondent notified the offeror the following day. On May 4th, complainant's attorney sent an email to respondent's principal broker. Respondent states that they
Can I interrupt just a second?
Yes.
I think a lot of this it's a contract problem, and I know that you've got the recommendation is a letter of instruction. I'd like to just go ahead and I'd like to make a motion that instead of a letter of instruction that we require the respondent take a 4-hour contract class. I just think with all these things going on, they just don't really completely understand how to do a contract. So my recommendation is a 4-hour contract class, got to be done within 180 days, does not count towards their CE.
Second.
Second.
All right, you've heard the motion. Instead of the council's recommendation, the proposal is to offer a consent agreement that requires a 4-hour contracts course to be completed within 180 days with other typical stipulations. Any discussion? Let's vote on that. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 7 is a represent.
All right, so this is a represent, and actually number 7 is not being represented, but we wanted to include it. It's the principal broker that's being represented, so the affiliate broker's complaint is just there for added context.
So we do 7 and 8 at the same time, or
We're really just doing 8. 7 isn't there for your consideration. It's just for context.
I can check 7 off.
Yes.
Thank you. Number 8. And let's go with new information.
Just the new information.
And whatever background you think we need. But
I think you've got the background. I can summarize briefly and state that in this case, well, I'll just read the new information. Okay. I think it's pretty straightforward. Okay. In the original presentation of this complaint, counsel overlooked the fact that the affiliate broker was released from respondent's firm on February 9th, 2018, while the events that formed the basis of the complaint against the affiliate broker began on February 14th. Further, respondent provided documentation which shows that up until the time the affiliate broker was released, respondent was active in the supervision of respondent in the subject transaction. And then I will also just add that they submitted the TREC Form 1 with the commission on the 9th. It wasn't processed until later. I believe it was processed on the 21st, which was one day after this affiliate broker's complaint was filed. The TREC Form 1 does retroactively date back to when they filed it. That's why the complaint was opened up in the first place. Now, looking back on it, I don't see any evidence that this affiliate broker was under the principal broker's supervision at this time, or at time of the complaint.
Is there a motion to adopt council's recommendation?
Yes.
Motion by Ms. Taylor, seconded by
Second.
Ms. Hills.
And I have a question.
Ms. Hills, you have the floor.
So, was this affiliated with anybody during this time then?
I believe it was a transfer and release, so they I think they were. I'm not. Caitlin, do you know?
So when Kelsey brought this one to me, I looked into it, and I can see how Centralized didn't open it against the new principal broker because, let's just say, I don't have the dates in front of me, but they submitted the transfer on February 9th. They mailed it to us. We probably got it on February maybe 11th, if that was a good mail day. And then that comes into our system, and we have to process it and remove the person from the firm that they were at and transfer them to the other firm. So even if we got it on February 11th, it would be a couple additional days until our system reflected where they were. So I think all of these events, the complaint filing, the transfer, all were sort of happening at the same time. And so when the complaint was opened, while we had received their check, we had not actually taken them from that firm to the...
And so on number 7, it says it was open February 20th. So so you're saying we have the wrong broker. Should we have had a different broker?
You know, I think at the time that the complaint was filed, they had just joined that firm. So
this firm that this broker
that
is.
The firm that this is the old broker. They had just joined the new firm. So, I mean, that principal broker really wasn't, I wouldn't say, supervising them yeah.
We actually do have a rule that says as soon as the commission receives the transfer release form, that principal broker is no longer responsible for the affiliate supervision. So this principal broker's responsibilities would have ended on the 9th.
So just the licensees one responsible, so no brokers are responsible for anything, new or old, right?
In this specific
I
situation.
just wanted to be sure I had my hand around. Okay.
Hey, let me try it this way. Okay, if the broker's at company A, and now that agent now is at B, okay, when that agent wrote this contract that's brought this up, did he use company A's forms? Like, who got the commission, company A or company B, where the agent is now moved to?
That I do not know.
Because whoever got that money is responsible for what happened on this piece of paper.
That I couldn't tell you who got the commission. This was a pretty confusing situation where I remember when I was first presenting it, it wasn't even clear if the transaction closed. I believe I learned later on that it did, but I couldn't tell you off the top of my head.
But let's just say, if I was broker B and I just got this person and I had a problem, I don't think I would want the commission to go, oh, well, they just got them, it's not their problem. No, I want to know that I just inherited a problem. I mean, and that's somebody I really need, and it makes me question why did they leave the company A? So is it possible for us to find out which contract this was written on, which company got the commission?
It is. I will just say, though, that in any event, now we could possibly open administratively a complaint against the new principal broker, but in any event, I don't think any action can be taken against the current principal broker because the commission received the release form on February 9th, which was 11 days before the complaint was actually filed.
There's no broker involved.
I know that opened up another can of worms.
Well, the broker involved should be the one that got paid.
Yeah.
Well, they did, and it would have been the first one.
Be the broker.
That would have been the first one because he wouldn't have been taking it to the second one.
How hard would it be to look this up before we leave here to figure out who the broker is, who got paid?
If we could come back after Erica's presentation, I can look through the files and see if there's any indication of who got what.
Okay, let's do that.
Okay.
That'll be real quick.
Just to be clear, the event that caused the complaint occurred after the affiliate was released.
Yes.
So in no case, so the broker we're dealing with here is the current broker.
Is the former broker.
The former broker. So it could have occurred on the former broker's watch. It could not
No.
have.
The affiliate broker was released on February 9th.
That's when they mailed it in. We didn't receive it that day.
Okay, so we received it on the 11th, on February 11th. The actions that formed the basis of the complaint occurred starting around February 14th. We processed the form, the release, on the 20th or the 21st. So when this complaint was open on the 20th, because in our system it still wasn't showing that this affiliate broker had moved to a new firm, it was open against the former principal broker. I think it was just the next day that the system acknowledged the transfer to a new firm. So, but for that processing time, I think this complaint would have been opened up against the new principal broker. That principal broker just wasn't in our system yet.
So administratively, you could open up a complaint against the new principal broker.
I think we could do that.
But as far as this complaint goes, it's clear to me that it should be dismissed.
Yes, and just to chime in, the rule that we were mentioning is on the page, on the top of page 83. So 1260.02.021 address is when the old principal broker's supervisory role terminates upon receiving the Trek 1 form. So it terminates once we receive it, which would be the 11th, which is before we receive the complaint.
But what was the date of the action?
Yeah.
It's after the transfer date.
The date of the action forming the basis of the complaint was the 14th, and we acknowledged receipt of the form on the 11th.
So I just need to be sure we're talking the same thing. My action is not when we received it and things. It's when did he fail to do this? When did the licensee fail their client?
Beginning on or around the 14th.
Okay. All right.
So I think the appropriate action would be to, this is just me, but dismiss this complaint. Then if you'd like to instruct staff to open administratively a complaint against the broker of record on the 14th or whatever date you want to use, that would be appropriate.
But what would that complaint be? I mean,
same thing.
Not supervising, but
this complaint was an alleged failure to supervise. I think that would be the only option if we were to open up an administrative complaint against the new PB, principal broker.
Rather hear the stuff before we vote on this?
No, I'm good. I'm good. I guess we can make a motion now that we dismiss against this broker and then open up a complaint against the new broker.
Second.
No, I don't think it matters now. I don't think it matters.
All right, the motion on the floor made by Mr. Wood, seconded by Ms. Hills. We'll accept council's recommendation and dismiss this complaint against the affiliate's previous broker, and then request administration open up a complaint against the broker of record as of the middle of February 2016. Okay? All right, let's vote on that motion. If you're in favor of it, vote aye.
Aye.
If you're opposed, vote no. That motion passes unanimously. Thank you, Ms. Bridges. Good job.
Thank you.
Miss Erica, now that you're feeling better.
I feel so much better.
That's good to know.
Are you hearing better?
Now that's what you're supposed to do.
I feel.
What'd you say?
I'm blushing.
he loves the banter.
All right, Erica.
Okay, number 9, 2018-025-651. Complainant is a potential buyer who lives in Florida, and respondent is the listing agent. Council notes respondent's spouse is also an agent and is a respondent in the complaint below. Additionally, respondent's father-in-law is the builder of the home at issue. Complainant came to Tennessee and viewed the property after seeing the listing, which showed the home to have 6,649 square feet. Complainant did some research after viewing the home and found the home on realtytrack.com and homefacts.com, where it was listed as having 3,669 square feet. Complainant alleges respondent told complainant the square footage was listed using, quote, under roof, end quote, square footage when respondent was asked about the difference. Complainant alleges it is now clear that almost 3,000 square feet is a, quote, attached garage area. Complainant states respondent's listing is highly deceptive, and it seems to complainant that it was willful on respondent and the spouse's part. Complainant concludes this for two reasons. One, respondent indicated respondent's spouse was the actual builder, and two, the motive appears evident as the sellers are the respondent's in-laws. Respondent's principal broker responded on respondent's behalf with both affiliates' names on the signature line of the correspondence. The broker states complainant first contacted the broker by email on April 16, 2018, 2 days after complainant viewed the property. Complainant demands the broker pay for complainant's travel expenses in the amount of $415 immediately and without investigation, despite the broker's response that the listing was temporarily suspended on April 18, 2018, so the broker could investigate further. Complainant threatened to contact other state agencies to slander the broker and the firm's reputation. After the threats continued, the broker told complainant there would be no further communication regarding the issue of complainant's demand of compensation, as the firm would not be paying for the travel expenses. Respondent notes complainant fails to mention complainant made an offer after viewing the home and before bringing up the issue and threats, and states the threats and complaint filing occurred the same day the sellers countered complainant's offer. The broker met with respondent and the agent below on April 23, 2018, face-to-face and discussed the issue of the square footage of the home and the listing at length and in detail. The broker asked the agents to explain the reasoning they used to determine which areas of the home would and would not be included in the calculation of the square footage, which ended up on the original listing. The broker concluded and explained to the agents that the agent below, when discussing and calculating with the seller and builder to determine the square footage, incorrectly included one of the two garage areas. Both garage areas are fully finished with full HVAC conditioning, fully drywalled, finished ceilings and floors with baseboard trim, and both were included in the square footage originally. The broker determined the garage area that is connected to the main home and living area and can be directly accessed from it should be included, but the garage area that is not directly attached should not have been included. The broker notes the other things that caused the huge 40% difference in the square footage between the original listing and the county's calculation is due to the fact that the owners completed much additional work in finished areas since the county's tax appraiser's assessment was done, and the square footage had not been updated to reflect the changes. On May 23, 2018, the listing was returned to active status again, showing 5,852 square feet, as the one garage area discussed above was left out of this calculation, the one that is not directly connected to the living area. You have to go outside to get to that area. The broker included a 2-page worksheet showing how this was calculated and provided the corrected listing. The broker notes this should not be viewed as an indication of guilt or misrepresentation, but instead an attempt to be as accurate as possible. The broker and agents deny intentionally misrepresenting or trying to deceive anyone or the complainant with the original listing. Counsel considers the fact that the square footage of the fully finished living area was not necessarily incorrect. It was just not detailed properly and could lead to confusion unless a buyer views the property as complainant did. Therefore, counsel recommends issuing a letter of warning to respondent for failing to exercise reasonable skill and care when determining what square footage should be included and what should not, as well as what details to provide regarding the square footage number, depending on what areas are included in the total square footage number given in respondent's spouse's listing.
Recommendation is a letter of warning.
It is a letter of warning, yes.
All right, Commission.
I think it's going to take more than that because, first of all, if you have finished space that's not livable, the garage is not livable, it should not be counted as full square footage. It's like a finished room in the attic. It's at a different point. So to me, the broker didn't know what he was talking about.
But it had air conditioning, it had drywall,
It
it
have
had
on the floor.
trim.
I have
Concrete with the garage door opener.
So, just to be clear, we're talking about the affiliate broker at this point.
Oh, yeah.
We might move on to the principal broker.
The agent. The agent involved here.
And I looked up, today we approved a class, the very first one, and it was ANSI number Z765 square footage method of calculating. And I thought, what is that? And I looked that up, and it talked about there's a difference in how appraisers and how people from your county come and measure, and how a realtor measures. And that is a standardization of putting the two things together, which really made me confused. So I think it's very important that we be able to say, this is how we measured it, or have someone else measure it. But I think that's the problem, is they weren't using the same even.
Well, let's talk about this. The affiliate broker originally put the property in the computer, let's say. That's who we're talking about.
Right.
So do you think a letter of warning?
Do they have a disclaimer?
Take more than that, because I think any agent ought to realize that different spaces, finished or not, like if you have a attic room that the ceiling isn't high, it may be a room, but you can't count it full. So if to me they had said, all right, the home living space is this, but you have a finished garage with these of that, then it would have been to me no problem. This is a problem.
So do you want to make a
well, I don't know what
proposal?
class you would take or something. I think, what would you do if you don't know how to measure or don't know how people know how to
Oh, they need to take this class right here.
The one
Well,
that's
how
coming
about
up.
here?
Change anything. The owners were currently using the garage space as a living area with couches and a TV and entertainment area in one of them.
So it wasn't new construction.
Well, it was new construction. They built it. The sellers built it and then haven't lived there very long. I think they built it to sell it. But it is a very, I have pictures of every single room, and it's a very fancy home with a lot of special features. And I guess I went with a letter of warning because I felt like it was confusing to anybody whether this is livable space that should be included or not. And I didn't feel like they intentionally misrepresented this. I think it could be considered living space, even though
something has a garage door. In Nashville, what's happening is you tear down one, you build two. A lot of them have garage doors that totally open up into your living room.
It's trendy. It's
very
actually,
trendy.
people
so you
want
can't just
that.
say a garage door made it a garage. We have one on our restaurant.
But I don't think if an official appraiser went out and appraised that property, that he would appraise that at the same, if it were
same dollar value.
Yes, he would say, okay, this is 2,000 square feet, but we can only count it as this because you don't count it the same. Okay, that's what I'm trying to get to.
Well, it says that the complainant did view the property before they made the offer.
The complainant
so they were there. They could feel
came from Florida.
The difference
viewed it.
in square footage is 797 square feet.
Well,
by my math,
the total square footage of everything in this property, whether it's garage or living space or not, that was never wrong. It was just how it was broken down.
Right. So the detached garage.
Right.
would be the one thing not in
Right.
not in the 58.
Right. So
that's 797 square feet.
Correct.
But the detached garage was finished off
Yes.
with heated. So why can we not count that as square footage?
Well, that's why I thought a letter of warning was appropriate, just because I don't
What are we
have
warning
a
them
copy
about?
of the original.
I think they got it right. I mean, if it's heated and cooled, it's finished space, it's square footage. And now, the problem that was wrong was these other websites were wrong. I mean, that started the whole thing. To me, it looks like it's finished square footage. The agent got it right. And so I don't know why they get anything. I mean, that should be dismissed.
Did they have a copy of the MLS listing attached to the contract? Or did the contract say they were buying at so many dollars a square foot?
We had one. We had a listing like this, and it was very nice. And they used part of that as a den. They did pull this expensive car into it, and it was totally attached to the house. And I mean, there's no difference. We included it, but we noted that this much that's included in this total square footage has the capability for a car to be pulled into, but it had a bathroom, it had everything finished.
Fontaine, I'm going to give you, in my opinion, you've got the first crack at making a motion. You may
Well,
not
I
want
don't
to.
know what-
Let's hear Rick
I
Douglas.
think it's-
Everybody else.
I'll wait till the motion's
I'm going to
made.
get over there.
Well,
Make my
to
comment.
me, it takes more than a letter of warning, but I don't really know what.
What are you warning them of, though?
Oh, if you want to just wait, that's okay with me.
Yeah, I'll wait for a
Okay.
minute, yeah.
With that said,
I'll
Rick.
sit back.
Yeah.
Just like to offer this for consideration that I don't think any of us are experts on how to measure a house. You have uniform, practices of appraisal. I forget what the uniform standards. Was it USPAP or something? I mean, that's one. They have one methodology they use for measuring a house. The local assessor may have another. If you've got knee walls, you don't get to count the whole square footage. But we shouldn't make our decision based on how the square footage was measured. Maybe we can make our decision on how it was disclosed. We disclosed that it was measured in this way. Okay, and I think maybe just a letter of instruction or a letter of warning is quite appropriate in this particular case.
So you have the floor if you'd like to make a motion. I'm going to Mr. Wood next because I think since he has a motion, but I want to, since you have the floor, you want to accept council's recommendation, make a
Yes,
motion to.
I'll make a motion to accept it, yes.
So there's a motion by Commissioner Douglas that council's recommendation be adopted and a letter of warning be sent to this licensee. Is there a second?
I'll second it.
All right, the motion is properly made and seconded. It's on the floor. Is there discussion on the motion?
I think this letter of warning for failure to exercise reasonable skill and care would need to spell out what skill and care that they were negligent in, and say something about square footage, not just.
I agree with you, and maybe they should have just disclosed what method we use to measure. But we're not experts on how to measure, so our decision doesn't need to be made based on whether we think it was accurate or not.
All right, so I'm going to go to Commissioner Wood to see if he wants to make a substitute motion so I can get this in the order correct. Mr. Wood?
Yes, I would like to make a substitute motion that we dismiss. My feeling is they got it right. I mean, there is a difference between maybe what they will get per square foot for this square footage, but they disclosed the right number, so I don't have a problem with that. So my motion is dismissed.
Is there a second to Mr. Wood's motion?
Second.
A second by Ms. Hills. So now the appropriate motion on the floor is to dismiss. If it fails, we'll go back to Mr. Douglas's motion to send a letter of warning.
Did she find on that contract, was the contract, did it have the MLS sheet that had the square footage attached to the contract, or does the contract say they were buying it so many dollars per foot? Or is it just a $300,000 house?
It's just a price on the contract,
Okay.
and I only have the corrected
That's all I
MLS listing.
All right, we're going to vote to dismiss, and we're going to ask Ms. Maxwell to call the roll on this one.
If you vote yes, you're dismissing.
If you vote yes, if you vote anything but yes, you may be saying you want to consider Mr. Douglas's motion.
Commissioner Douglas?
Yes.
Oh.
No, wait, I'm sorry. I thought you were going to ask me something. My vote is no.
You want take two?
Record Mr. Douglas as a no.
No. Commissioner Marcia Franks?
Yes.
Commissioner Diane Hills?
Yes.
Commissioner Fontaine Taylor? No. Was that a no?
No. Yes, it was a no.
Commissioner Bobby Wood?
Yes.
Chairman John Grease?
Yes. All right, that motion passes, and so this complaint is dismissed. I really thought it was going to be a tie.
I know you love those.
Fail, then we get back, which yours would have been unanimous, I'm pretty sure, at that point. But shows you what I know. All right, now we're on to the spouse of the builder, who's also a licensee. Is that correct, Kelsey? Erica?
Correct.
Okay. Is there anything different here that...
Well, do you want me to read the number?
Please. Yes, I do.
Number
Thank
10
you.
is 2018-025-691. And no, there is nothing different. I will add that the respondent is the co-listing agent as well as the spouse to the affiliate broker.
That makes a difference.
And that is disclosed. There's proper disclosure signed and.
Motion to dismiss.
Second.
Motion by Ms. Hill, seconded by Mr. Wood. Does this complaint be dismissed? Per count. Oh, that's not council's recommendation. In lieu of council's recommendation. Bless you.
Bless you.
Discussion on this one. Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Now we get to the principal broker. Bless you again.
7511.
Move to dismiss.
Second.
Motion by Ms. Frank, second by Ms. Hills. The council's recommendation be ignored, and we dismiss the case instead. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 12.
2018-025-431. And I think I might be the culprit here of who did not appropriately put who the complainant is and the respondent. So I'm going to do that. Complainant is a buyer, and respondent, from what I can tell, is they are out of business. Their website is no longer active. The BBB has, I guess, unaccredited them because they've received 17 complaints in the last 3 years. And according to the BBB and what I can find on the internet, the respondent advertises to sell timeshares, but I can't confirm who the respondent is for sure because I didn't get a response and there's no other information. Complainant alleges complainant and their spouse entered into an agreement for 1 year.
Wait a second.
Yeah.
Well, I don't think you need to read this into the record. We don't even know who the respondent is.
Well, I mean, I know the name of the respondent company, yes. I just can't tell you exactly what the business is because the website is down and they didn't respond.
But you have the name of the respondent,
absolutely.
not the company, the name of the respondent.
Oh, yes.
Okay.
Yes.
So I'm just trying to determine.
So but the next to the last paragraph says it was signed by an agent of respondent. You mean agent? You mean person?
Next to the last paragraph.
Respondent received
An
a
agent
copy
can be your secretary.
of the complaint.
Yeah,
by
or-
certified mail.
Just on the certified mailer, there's a box that literally says agent, and that was checked. So I used that word.
So the name that you have as the respondent did sign for it.
No, the name I have for the respondent is an LLC, and the agent who signed the green card is the name of a person.
Which could be, like in our case, our accountant.
Yeah.
Or our registered agent.
So you got no response back.
Correct.
On a letter you sent to an entity that's not licensed to sell real estate.
Correct.
So we can't get them for failure to respond.
Unlicensed activity.
Which is my recommendation.
Move to accept council's recommendation and also to add a cease and desist.
Second.
Motion made by Ms. Franks, seconded by Ms. Hills, adopts council's recommendation and includes a cease and desist letter that I think is that standard at this point?
Yes.
It's going to go.
But I have a question, too.
You've got the floor.
So, in the first paragraph, 2, 4, 6, about 8 lines down, it says complainant alleges that they called respondent's customer service line several times. Did we have a customer service line to call? Did
No,
we try that?
We don't have nothing that I was provided was I could not no numbers were working. The website, I had a website address and it wouldn't even load. It's gone. And then I'm almost positive when I first read this complaint, the BBB, they stated that this company is not accredited, but since then, when I just looked today, it now says that it's out of business. I'm almost positive that was not there before.
Do you have an address for the respondent?
Yes,
Okay.
we mailed it, yes. And they signed, somebody signed for it.
Other questions? Motions to accept council's recommendation. Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Next up.
2018-026961. Complainant is anonymous and respondent is a licensee. Complainant provides a screenshot of what appears to be a Facebook page for respondent's real estate team along with one other agent who is the respondent below. The handwritten note on the screenshot from complainant states, quote, no company info, end quote, and, quote, Facebook post. Respondent states they made a mistake by not reviewing the post more stringently. Respondent has since corrected the mistake and appreciates it being pointed out. Respondent states being new in the business is no excuse and apologizes for having an infraction, but states respondent will be more diligent in the future in looking into what is posted on social media and other mediums. Respondent provided the corrected screenshot of the same page showing the firm name and firm number. Council notes this page only included posts of alumni softball and baseball game events and that kind of information, and council did not see any posts about real estate listings or properties. Council finds clear evidence respondent violated advertising rules and recommends assessing a $500 civil penalty for failing to include the firm name and firm number on a respondent's real estate team's social media's page. Also considering respondent was not offered an agreed citation, which would have been in the amount of $500. That is why I went with 500 instead of 1,000.
Motion to accept council's recommendation.
Second.
I have a motion by Ms. Hill, seconded by Mr. Wood, that council's recommendation be adopted and this license to be offered a $500 civil penalty. Before we vote, Caitlin, in cases like this, I'd like to consider you a witness. Because did this cross your desk and you chose not to offer the civil penalty?
I would assume that. I have typically stayed away from some of the Facebook stuff because it's a little bit less clear-cut than just an actual advertisement.
But it's so rampant. I mean, every day I see tons, and I always do the one click, and it's not there. I mean, it's rampant. People are not doing this. So we either need to have the rule and make everybody abide by it, or not have the rule. And I guess it's up to this real estate commission to decide what's important to you. Do we want it or not?
And also just point out too, I mean, this person was, hadn't been licensed a year and already seeing this. I'm seeing a lot of that. I hear when I'm out, people want to throw stones at grandfathered agents. That's where the problem is. I think it's the agents that we're seeing is 2 years and less. That's where we're, just like the young lady that was here before, she already had a violation, but fortunately her broker had seen it, or I may have felt different about my vote.
But the problem about that was he saw it. I saw it last night, and it was still on there.
Yeah.
It wasn't taken off. They didn't take it off. So we either got, because everybody's doing it. That's what everybody's going to say. Everybody's doing it. Why you pick me out? So we have to decide, and maybe we can discuss this next month or something. But it's rampant.
All right, you've heard the discussion. Is there more discussion? Are you ready?
Was the motion
The motion is to accept council's recommendation.
Okay.
Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 14 is related to what we just heard.
2018-026941, and the respondent is just the other agent on the team page. There's no other new information.
Motion to accept council's recommendation.
Motion by Ms. Hill, seconded by Ms. Taylor, that council's recommendation be adopted. Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 15.
2018-026981, and the respondent is the principal broker for the affiliate brokers above. So my recommendation was a $500 civil penalty for failure to supervise.
So this person didn't supervise two people. Not one person, two people.
Two people, one page.
I mean, to me, this business has gotten so hard because some companies may have 800 realtors or licensees, and then some of us have 12, 15. I don't know how anybody could oversee Facebook really, if you have lots and lots of agents. I mean, you need even a person with a full-time job of checking that out wouldn't be able to do it.
So what do you think, Ms.
So do we have a motion yet?
Yes.
Okay.
We have a $500 civil penalty. At which time you pointed out there are two different agents, and you gave me the reason to think you might be interested in doubling that because there were two agents. But are you inclined to do that?
Well, let's see. Yes, I'll make a motion, amend the motion to $1,000.
All right.
And we can just see.
Is there a second to Ms. Frank's motion?
I withdraw it.
Don't withdraw it. I like to say it. I want to say it failed for lack of a second.
No. Go ahead. You may say that.
Failed for lack of a second.
Okay.
All right. We're back to the motion on the floor, which is to accept council's recommendation. Let's vote. Those in favor of that motion vote aye. Those opposed, no. The motion passes unanimously. Number 16.
2008.
I don't know that we had a. Could we reiterate the motion?
The motion was to accept council's recommendation offered by Ms. Taylor and seconded by Mr. Douglas. They may have a hard time remembering that, but I heard them.
I kind of did it under my breath a little bit.
Well, that's because they're farther away from everybody else. 16.
2018-026191. This complaint was opened administratively after a random audit was conducted by the TREC audit process against the respondent, who is a firm. The audit produced two findings of trust violations committed by respondent as follows. 1, a trust money deposit for one of 6 sampled contracts was delayed by 1 day. And 2, a review of banking records revealed that commissions related to sales were being deposited and dispersed out of the escrow account at the closing of the transaction. Specifically, the first violation occurred because a $500 escrow payment was received and a contract entered on July 15, 2016, with the contract stating the money must be deposited within 5 business days. Respondent did not deposit the escrow payment until 6 business days elapsed. Council first notes that
I'd like to make a motion.
Sure.
I'd like that we accept council's recommendation, so we don't have to read the whole thing.
All right, Ms. Frank says properly interrupted the narrative and made a motion to accept council's recommendation. Is there a second to that motion? Seconded by Mr. Douglas. Discussion on the motion.
Let me look at here about earnest money 1 second.
So, I have a question.
You got the floor.
So, this is a retired broker now that
Complaints against the firm.
that did this, correct?
So the respondent is a firm, and when the violations occurred in 2016, there was a broker that is now retired, and so the response came from the current broker who was not there when the violations occurred.
How can we flag the retired broker? The retired broker could get their license back out, right?
This is a complaint against the firm, not the broker.
I know, but if that broker was not retired, we would be hearing it, correct?
Perhaps something.
I mean, I don't see why we can't have open a complaint against the broker who is responsible for the firm's violations, seeing as the firm can't make decisions.
I mean, it's a.
I feel like they're getting out of it
commissions
here.
related to sales were being deposited and dispersed out of the escrow account at the closing of transactions, and that was the broker then.
Yes, the broker was
Oversaw
the broker.
Yes.
And the
So
broker set up the
we have
incorrect
nothing-
way.
If we, and I understand not holding the new broker, I get that, but there has to be some way that we flag who was doing this at the time.
The audit was of the firm.
Right. So we can either discipline the firm or open a complaint against the previous principal broker and discipline that person. I wouldn't think we'd want to do both, but I'm not sure.
Previous brokers in retired status, all we probably could do, I asked this question, is probably flag it in case she takes her license out of.
I think we can assess discipline as we would for an active
But
broker.
even if we flagged it, we would have to open something
Yeah,
then
we
to
could-
flag it.
We would open it and we can assess discipline. Right? I mean, we can open a new one. Right?
Well, could it be that that the same letter of warning, the recommendation, go to the firm and to that previous principal broker?
But we never took out something against that previous principal broker, so they never had an opportunity to respond.
Oh.
See,
Yeah, we'd have to open
because to
one.
me, that's who really needs to
Right.
be flagged, is that broker who was doing it.
Open a complaint, send the previous principal broker the complaint, and allow that broker an opportunity to respond. Then I would present it to you.
My motion would be to dismiss this against the firm, but open the same complaint against the then existing principal broker. Period.
Second.
So the motion on the floor, offered by Ms. Hill, seconded by Ms. Franks, if approved, would dismiss the complaint that was administratively instituted against the firm and request administration to open a complaint against the broker who was the broker of record at the time the violations occurred. That's what's in front of us. Discussion. Mr. Wood?
I guess, and I kind of look at these as two different things, but on the earnest money part, I mean, we're talking about a day, and then like I noticed that in the summary it says business days, do you recall if they altered the purchase and sale agreement to say business days? Because ours says calendar days. I tell you what, doesn't even matter. Here becomes my issue. It's a day, and then like depending on what time I might deposit my money, it may give me the next day, or at least I used to do that if I deposit late in the day. I don't know that I want a federal case over one day.
Give them some
Right. I know a weekend was involved. I'm positive of that.
In our contracts, the contracts I use say if it hits on a weekend, the deadline is you get until Monday, or Tuesday if Monday was a holiday. So again, I don't want to be one day shouldn't matter. It's not enough to make a case over. Now the other way, how they were doing the commissions and stuff, that's a problem. And maybe for the current broker, he just needs maybe a letter of instruction. I mean, it sounds like maybe he's already corrected that.
Oh yes, the current broker has corrected the commission problem by opening the proper accounts, and also has corrected the other issue by changing their contracts from saying 5 business days to 7 business days. They feel like that's enough so this wouldn't happen again. And that happened as soon as the audit occurred.
All right, the motion on the floor is to dismiss the complaint against the firm, ask that a complaint be opened against the broker of record at the time the events occurred. If you're ready to vote, let's do it. Those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Number 17.
2018-027-321. And I'm going to state who the complainant and respondent are. So complainant is a resident of Florida and a timeshare owner, and respondent is an unlicensed company that is located in Tennessee that did not respond, that I believe is very similar to the one we discussed, that advertises to buy and sell timeshares, but actually has 52 complaints with the BDD in the last 3 years. That's about all I know about respondent for sure. So, complainant is a resident of Florida who is allegedly...
Okay, we don't need to hear all that, I don't think.
Okay.
What does the advertisement look like that this company does? Did you...
There's no website. Again, well, actually, I'm sorry. There is a website. You have to have a user ID and login to be able to see anything. There's literally the name, and that's it.
They buy timeshares from people who already own them, or are they selling timeshares?
I think they are scamming people with
That could be-
timeshares in whatever way they can. Whether that is convincing them they're buying them, or selling them, or renting them, or...
When you contact the Better Business Bureau, do they send you their file, or what do they do?
We ask, they will send us their file. So we have not received anything from them. I just did internal research, and I could see on their website that there's that many complaints. But I'm pretty sure this complaint went to a bunch of agencies in Tennessee and Florida, and I do have some of their files, their records.
I'm interested in this case in some sort of penalty per complaint. And so if there are 52 complaints filed against...
But that was with the Better Business Bureau, not with us.
But if they have information that shows that people feel like they've been scammed on timeshare units in Tennessee, I don't know why we couldn't use that information as part of the basis for us to make a decision.
Until they respond and prove otherwise.
It needs to go to the district attorney's office.
So I'm kind of in the mood to ask that this be put off till next month, and you see how many different complaints you can confirm.
Second.
That's just my feeling on it. But if they're going to play a game and they've got 52 complaints with the Better Business Bureau on timeshare units that we're supposed to regulate, I'm not satisfied with a $1,000 fine.
And can we, do they give you any more information other than there's 52 complaints? Are they turning it over to the district attorney's office, or?
I believe once I ask them that they will let me know if they've turned anything over, and they will probably give me a copy of every single complaint they have. They've worked with us in the past, so I think I can get a lot of information and bring it back to you. And this company is located in Tennessee, which bothers me a lot more than a company that is not, which,
So why don't you see if you can get some more, flesh this out a little bit more.
Okay. And then I'll represent it.
Oh, you grumpy John Grease.
What did you say? All right, so without objection, we're going to defer this till next month's agenda. Is that okay?
Yes,
All right, anything else, Ms. Smith, to come before us from your perspective?
Nope. I appreciate you guys, your patience with this
It's
today.
always a pleasure talking with you.
when I feel good.
Yeah, especially when you feel it. Thanks for your effort, too. All right. Let's see. Anna, anything you have left for us?
No.
Miss Maxwell?
Nothing.
Nothing. What about Aaron? Anything? We haven't got you on camera today, so I just want to make sure everything's good. All right, guys, thanks for working through lunch again, staff especially, commissioners. Fontaine, anything on your way out you want to say?
Oh, it's nice to get out early.
Listen, you guys are efficient,
Right.
professional, and it's working well.
Get her done.
Diane?
I did have Janet reached out and said that she and Bear are going to meet for dinner Tuesday night in Knoxville. If anyone wants to join. And
could it just be Janet, not Bear?
It could be.
Okay.
and look forward to seeing you in Northeast Tennessee next month.
Thank you, ma'am. Rick?
I don't think I'm going to be able to make it to Northeast Tennessee next month, unfortunately. Going to the Arello conference or whatever it's called, and it's going to take me away from home too much. I need to be at home more often.
So. I get to St. Louis quicker than you can Johnson City.
Oh, definitely.
Oh, yeah, you can.
Yeah.
Wow. All right, man. Anything else?
No. Enjoyed today's meeting, and I sure appreciate everybody's participation, and you guys did a great job. And Mr. Chairman, you did a great job getting us out of here early. So,
all a team sport. I'll take effort. Bobby?
I was just wondering if Kelsey and Erica, if they dream about timeshares now, since that seems to be what we're talking about all the time.
Nightmare about timeshares.
That's what I was thinking. That's what I was thinking. But I'd like to thank Caitlin for getting everything together for the presentation to Karen Lowe today. It was awful nice, and getting the photographer and stuff here. Thank you for doing that. So.
Marcia?
Been a great day, I think, and everybody be safe going home.
Correct. Caitlin or anybody on the staff, so like you said, you had a meeting with timeshare organization personnel. Really, if any time you think it would be beneficial to this commission for a representative of a group like that to come and just give us an update on what's going on in the industry, I'd be all about that.
We actually mentioned them. They asked if you guys would be interested in something like that because we mentioned how often we have timeshares in front of us and we ask them, one question that can often be answered multiple different ways, and is that common? And especially as it relates to points. And then they said yes, that was that. Depending on the timeshare group, they view points differently, and so it's not odd that we get different answers from different groups. But they did entertain that idea. So
well, if you get a chance, put it on the schedule. Just tell them we need like a 15-minute presentation. Okay, we don't need 2 or 3 hour presentation.
And especially if it could be one of the timeshares that maybe there were multiple complaints from this month.
So the group that we met with is ARDA, and so they are the timeshare. They're like the Rillo of timeshares, and so they had a couple of their representatives that came. And so it would more so be a general rather than,
Oh, and I also think it would be appropriate anytime you see something you think would benefit the commission, or as an example, I think we're about ready to get Cindy Rice back down here to talk about what coverage, insurance, what you get for what you pay for.
With that coming up, especially.
With that coming up, so at least we can ask questions because we're going to get questions. But just think like that. We're not opposed at all, or at least I'm not opposed at all to have somebody try to make me smarter. It doesn't take a lot, so just make sure you think that way.
Can I ask a
Sure.
question about speaking of insurance? Rice handles what percentage of insurance in Tennessee?
I don't know that exact number, but I could find out how many Tennessee policies that they write and then compare that to our total number of licensees.
I think they do like 26 states.
Well, I mean, but in Tennessee, because that's some companies, as you well know, go another.
Firm as an example. That's a good example, I would hope. All right, that's all I have. Thanks, everyone. Have a great month. Take care.
Thank you.